This is Caught in the Act with Tim Clarke.
Hello, my name is Tim Clarke, and this is episode 1 of Caught in the Act, a new podcast which will take you inside the courtrooms of Perth and beyond for a weekly discussion and dissection of the biggest legal cases of the moment. Now, in the last 7 days, you couldn't have failed to have been affected and confronted by the facts of the case of the state of Western Australia versus Paul Anthony Cannon. As that identifier states, it was a case about Cannon, a 55-year-old man who was jailed for life with a minimum term of 19 years for murder. His victim was his former wife, Lynn. She was yet another case of the most extreme domestic violence.
Paul Cannon stabbed Lynn to death in what Justice Derrick today described as a prolonged and vicious attack.
And in the hours before her tragic death, it also emerged that reports had been made to WA police about a woman in potential danger.
At 7:30, Christine made the first call to police. Other neighbours followed to report screaming. At 8:20, an eyewitness saw Lynn alive, pleading for help. Paramedics arrived 8 minutes later when Lynn took her final breath. Police arrived at 8:44. She was covered in defence wounds.
It took officers more than an hour to respond to 000 calls. And that was partly because they were already dealing with 2 other similar calls in the same area on the same night. And that on average, police respond to a report of domestic violence in Perth every 4 minutes. The Cannon case has brought into sharp focus the seemingly ever-escalating scourge of domestic violence happening behind front doors across our state. And it was also a stark reminder of how the court process which follows such a case can be almost as traumatising as the crime itself. Joining us today to help us better understand the complexities and delicacies of cases such as this is Bernard Standish, who's been a barrister on both sides of the bar table, prosecuting and defending for more than 25 years. Bernard, thanks very much for joining us today.
Hello, Tim. How are you?
Yeah, I'm really good, mate. So let's introduce you to our listeners first. As I said, you've got a career that's long and winding. It's taken you across the country and further afield. So just tell us a little bit about your career first.
So I started practicing law in Queensland, my home state, in the early 90s, and virtually have been exclusively practicing in crime since about 1994. And as you said, on both sides of the bar table. So I practice now from Albert Wolf Chambers in the city, and but I still take prosecution briefs as well as defence briefs.
So safe to say you've probably seen and heard almost all there is to see and hear in the law, although I suppose you never say never, and you never think you've done it all or seen it all.
Oh no, I don't see myself that way, but I have seen a lot of bad behaviour or a lot of incidences of domestic violence, domestic and family violence, and in your intro, Tim, you spoke about it being a scourge, and there's no doubt that it is a bit of a scourge in our society. And it's important that a light is shone upon these things that happen behind front doors, as you say.
Yeah, and as we mentioned off the top, the case of Paul Cannon is a particularly bad one. So I'm going to go through some of the details now, and just a warning that some of these details for some listeners might be disturbing and or triggering. So during Cannon's sentencing hearing in WA's Supreme Court, the court was told that the 55-year-old Cannon and his wife had separated around 2020, and he had failed to come to terms with the end of this marriage. So he spent the next portion of his life ruminating and had then begun thinking about killing his ex-wife in the weeks before he did. He also sent her some vile and abusive text messages calling her a lying, cheating slut. Yet the court was told Ms. Cannon continued to engage with him lent him money, and even gave him her old car. Then, on Lynn's 51st birthday, he travelled to her house in the morning, uninvited, where he discovered she was seeing someone else. Enraged, he then sent her a text message threatening to harm her and that he knew she had a new partner, writing, "I hope to be celebrating your painful death soon." The following day, he again travelled to Miss Cannon's house and threatened her with a knife. A few hours later, she then travelled to his Lansdale home in the afternoon to sign some car transfer papers. When Miss Cannon arrived, the pair began arguing, with the court told that argument continued for hours. By 8 p.m. that evening, it had escalated, prompting neighbours to call police. 10 minutes later, Cannon's landlord walked into the house and saw him holding his former wife by the hair and holding two knives before stabbing her in the chest with one of them and yelling, "I told you I was going to kill you." Ms. Cannon was stabbed at least 7 times in the chest. She also received stab wounds to her wrists, back, chin, thighs and elbows. Some of those defensive wounds. Justice Anthony Derrick said he was satisfied the father of two had intended to kill his ex-wife in the hours before he carried out the horrific act. He also described his actions as prolonged and vicious, adding that Ms. Cannon's last moments would have been terrifying and horrific. And he also said while Cannon had shown remorse, he was not satisfied that he accepted full responsibility, instead blaming his mental state and alcohol abuse when talking to a prison psychologist. Justice Derrick jailed Cannon for life with a minimum non-parole period of 19 years. And following the sentencing, Lynn's 3 sisters said they believed had police responded quicker, their sister would still be here today.
Lynn was failed. We were all failed. The knowledge that she could so easily have been saved has greatly increased our pain and suffering.
Now, Bernard, any domestic violence incident, even heard in the sort of sterile surroundings of court, can jolt the senses, and anyone listening to those facts couldn't fail to be affected by them. Given the family circumstances that envelop all domestic violence cases, with your old prosecutor's hat on, sort of how do you approach them when it comes to actually getting to the truth of what happened?
There's been some pretty significant reforms in the state of Western Australia in recent times, Tim. The Parliament passed the Family Violence Legislation Reform Act in 2020, which, as I say, was quite significant. The effect of that Legislation Reform Act was to create new provisions within the criminal code. New offences were created, including a persistent family violence offence. They also introduced an offence of strangulation, impeding someone's breath, which is a common form of, I suppose, family violence. And there were some major changes to the Evidence Act, such that if it's relevant, if family violence is relevant in the context of either a family violence offence or some other alleged offence, for example, an alleged offence of sexual penetration without consent, as between a married, albeit estranged couple or whatever, then evidence of family violence that occurred on other occasions can be led as part of that trial to help get a decision maker, such as a jury, to understand the dynamics of what happened inside that household. So I think the Parliament recognised in passing this legislation that people react in all sorts of different ways to family violence, and that family violence is something that is not just limited to acts of physical violence, but it can include sexual violence, it can include acts of coercive control. So that sort of scenario, that classic scenario, usually, I mean, I'm not trying to gender this, but it's obviously usually a male perpetrating the violence on a female. And in circumstances where, as it seems in that case study to which you've just referred, the perpetrator of the violence cannot accept a decision by a former partner to move on with her life without that man. So there is, as I say, and it's commonly used now by prosecutors, the provisions in the Evidence Act to allow them to lead evidence of other acts that aren't the subject of the charge on the indictment, but simply to put into context the dynamics of this relationship between people so that a jury would understand, for example, why it might be that a complainant didn't come forward to complain about being raped by her former husband because of the prevalence of the domestic violence in the relationship, for example. So,
and was that to subvert or prevent an accused claiming, it was just a one-off, it had never happened before, I was under a lot of pressure, and to get around that common defence, or?
Well, perhaps it's, I should put it into context. As a general proposition, the prosecution is limited to running evidence, leading evidence relevant to the charge that's being considered by the jury, and that a person's prior criminal history can't be led as part of the trial because if the jury hears about that, then they may reach a conclusion that if he's done it in the past, then he's done it this time. There are exceptions to that. And some of those exceptions include things such as propensity evidence, where if someone has a propensity, it's a recognised propensity to act in a particular way in the past, that person may be more likely to have committed the offence that's charged. This is a strengthening, I suppose, of that sort of concept, that evidence of what might be called disreputable conduct or the conduct that's not the subject of the count on the indictment might be relevant in determining whether what is being decided on the indictment has been committed by that accused person.
Yeah.
So it's a helpful tool to the prosecutors as long as it's not misused, I suppose. But
and going back to the current case, so in Justice Derrick's sentencing remarks, he actually flashed back 4 months before the actual incident itself to relate or relay a text message that Mr. Cannon had sent his ex-wife or estranged wife, and I'll quote some of it. "I hope and pray that you are dead before we get to court, because really you have been and always will be a cheating, lying slut. I just wish I was there to watch you die in agony as a bonus." So that not strictly part of the acts that were committed on the day that would have been, or the date that would have been cited on the indictment, but able to be taken into context as to what was happening in that relationship and what had led up to that fatal moment.
And indeed, I'm not familiar with every detail of that particular case, and I'm not sure whether it went to trial or whether he pleaded guilty to that charge. But on a plea of guilty, that sort of material would be relevant because the judge can inform herself or himself of all sorts of matters that would not necessarily be strictly admissible in a trial. But even if he took this to trial, that would be relevant, I would have thought, on a charge of murder, because it would go as much to his intention as anything else. So the prosecution in a murder trial obviously has to prove that the accused person committed the acts that caused the death of another person unlawfully, and that such acts were accompanied by a murderous intent, that is, an intent to kill that person, or an intent to cause an injury of such a nature as to endanger or be likely to endanger that person's life. So evidence of that text message would go directly to that particular issue, because it would be seen or it would be argued by the prosecutor to the jury that he was telling the truth about what his future intention was, that is to cause her death.
Yeah.
So it would be relevant.
And I should have pointed out earlier, actually, that Mr. Cannon did actually plead guilty to the charge. He didn't take this to trial, and it was on the day that he did plead guilty that his wife's sisters, three of them, first made vocal their obviously their grief at the loss of their sister, obviously, but the disappointment at the process that had gone on, getting or the interaction with family members of victims in cases such as this must be a particularly tricky line to tread, Bernard, in terms of how you go about traversing what is obviously a very traumatic experience for them, but you also have to boil it down to the facts that will either get a person convicted or assist in helping a judge sentence them at the end of the day. How do you approach that?
It's difficult. The immediate family members of a deceased person who's been killed unlawfully by another person are obviously very important. Everyone's death, if they're killed by another person, has an impact on everyone in society. Every murder is bad for our society, but obviously it has a greater impact on the people that love that person, the people in that family. So amongst the prosecutors, they're known as key secondary victims, and they are to be consulted the whole way through the process, so that they have some understanding of what might follow. And you, as a respected journalist who's been covering the courts for a long time, Tim, you would have seen family members turning up to the Stirling Gardens Magistrates Court where people charged with murder are processed until they are committed to stand trial, and they will often appear even at very brief mentions just to have some sense of support for their deceased relative. It's important, I think, from a prosecutorial point of view, to just be a bit cautious in the way that, you just need to have empathy with people, but you also have to be a bit realistic in terms of what you can and cannot promise a person, perhaps. Yeah. Whether you're defending someone on any sort of serious charge or whether you are prosecuting someone, you can't guarantee the result either way. And it's important that, the family members must be aware that the decision as to someone's guilt, particularly on a charge of murder, is in the hands of the jury. So it's you can't make promises that you can't necessarily deliver on, and it's a fine line because they only see it in one particular way, and also they're not familiar with rules of evidence and what things can be led, what things can't be led, because it doesn't fall within the rules of evidence. So it's just important to treat people with respect and empathy and try and do the best you can to keep them updated with the whole process.
And victim impact statements are also an important part of the process. They are legal documents that are placed before a judge, usually, or a magistrate that allow, as you say, a secondary victim or a victim, a primary victim in the case of a serious assault or a sex assault or something like that, to tell the court the impact of a crime on them and their ongoing life and how it's really affected them. Even there are rules to what can be put before a judge. And in this case, in the Cannon case, not only were they placed before the judge, but the judge actually in one case allowed the victim to read that victim impact statement out themselves in person in court, which is that's a discretionary measure that a judge has, and I'm sure you have, Bernard. I've seen both sides where a judge has refused and said, no, it's not going to help me come to a
I think there was a
sentencing.
time.
Sorry, John.
Sorry, Tim. I didn't mean to speak over you. There was a time when there was a concern that the person who had drawn the victim impact statement may go off-piste when they're in the witness box, and so that caused a bit of concern because their emotions can sometimes take the better of them, and when they're in that public forum, they may go off script, and so there's certainly nothing within the Sentencing Act that prohibits that statement being read aloud. So it is, as you say, at the discretion of the judge as to whether that will be permitted. It can have a powerful impact if the offender, because he is an offender by that stage, is in the dock and listening to a key secondary victim speak about the loss of their loved one, or listening to their primary victim who has been, assaulted by this man in the past, and to hear firsthand what impact that had on those people. It can be powerful.
It's some of the most powerful moments I've ever had in court, I think, is actually listening to a victim of whatever crime it might be tell their experience in their own words, while they're, in some cases, just meters away from the person that's inflicted that damage on them, whatever it might be. And in this case, as I said, one of Lynn Cannon's sisters was permitted to say her experience in her words, and some of those words were particularly powerful. She finished her sentence by saying this: "You are nothing. You will be forgotten, wiped from our lives like we would wipe the dirt from our shoes." And hearing that, and hearing some of the other things that he'd not only been accused of but admitted he'd done, Paul Cannon was actually in tears himself in the dock, obviously contemplating what his immediate future might be. Having people in the witness box, Bernard, that have been through these traumatic experiences, some of them obviously when they go to trial are still alleged. On the defence side of things, you're tasked with asking them questions about their accounts and at times having to pick holes in them. And again, that must be a really fine line to tread between going as hard as you need to represent your client, but not going too far that you might earn the ire of a judge or a jury or an angry family member, I suppose.
Yeah. Well, as lawyers, Tim, we're not judges, so and we have ethical constraints, obviously, in the way that we practice our law. So it's very important for the listeners to appreciate that in our democracy, our criminal justice system has to operate to allow people to be represented when they're charged with serious crimes. But it's not just some opportunity for a lawyer to go rogue and just attack people. That's not going to get you anywhere, and it's not appropriate. It's not within the ethical constraints. We're obviously bound by the instructions we receive, and if a client says, "I'm not guilty of this offence," and we take further instructions about the circumstances that he claims to have existed, and it's important that those claims are put to the complainant to allow her the opportunity to comment on it or to agree or disagree with those propositions. But it's also appropriate for her to be properly tested because allegations are merely that. They're allegations unless and until they are proven to the satisfaction of the jury beyond reasonable doubt. Now, I've been doing this long enough to know, Tim, that to adopt an attitude or to adopt a tone or to use language that is disparaging or is disrespectful or unnecessarily argumentative doesn't do your client any favours for a start, but also it just reflects very badly on you as an individual lawyer and is completely ineffective. So it's important that we be permitted, when we're defending people, to test people make claims against their client, but to do it in a respectful way. So it is, I suppose, a bit of a fine line, but anyone who's been practicing for any length of time will probably know, what line not to cross.
And you've seen that change over the years, I take it? I mean,
completely. So, as I mentioned at the beginning, I started my career in Queensland, and when I started practicing in crime, we still had contested what was called committal hearings. So something involving a serious charge that ultimately has to be decided by a judge and jury in our district court or the Supreme Court would start as a charge in the magistrate's court. And in those days, in the magistrate's court, an accused person was entitled to test the evidence contained in the statements of witnesses at what was known as a committal hearing.
Mm-hmm.
Now, that's in front of a magistrate, not a judge. There was no jury. The magistrate in those days had an obligation to commit the person for trial if the magistrate found that there was a prima facie case to answer. Now, the whole concept of committal hearings, I'm not sure exactly when they were abolished in Western Australia, but it was well before I started practicing here. But they fell into sort of disrepute to a certain extent in the eastern states because they could be abused. Let me give you an example. If someone was on a serious charge that didn't involve a murder, so the victim was still alive, but it was a serious charge, at the committal hearing, the lawyer representing that person could be abrasive, could be really quite robust in questioning of that witness.
That's a very legal term for being rude, obnoxious.
Oh, yeah,
arrogant.
Yeah, totally,
intimidating.
Out of control.
Yeah.
Intimidating. So, and the purpose for that might well have been, I'm not saying this was the case in everyone's case, but for many lawyers, it may have been in order to have an effect upon that witness when she gave evidence a second time in front of a judge and jury. So, and I've known of cases where a witness who was cross-examined in that robust way in the committal hearing in front of a magistrate only, virtually walked out of the courtroom in tears and deflated. And then when she returned to testify in front of the jury, was incredibly anxious and worried about copping the same sort of treatment again, only to find that the same lawyer who attacked her in the earlier stage was all of a sudden nice as pie because he may have achieved the purpose for which he did that at the committal hearing. In other words, to shatter her confidence. And she was then second guessing, well, why is it so different here? Because it's not the sort of behaviour that he wanted, that lawyer wanted to demonstrate in front of the jury. So anyway, it just became, I don't think the justice system could accommodate committal hearings for every matter the way that the lists are now. It already takes a long time before someone comes to trial, and if there's a separate hearing in the lower court, it would only blow it out further, leading to more costs to the community. And at the end of the day, it's not as though when we're defending someone, we don't know what the case against our client is when we go to trial in front of a jury, because the prosecution has a duty to disclose all of its evidence. So we have all that, So that's an example of how things have changed, Tim, So and other changes, I think that in contemporary society, I think the general public is just more fully aware that although the scourge of domestic violence and family violence is behind, closed doors in the community, I think there's just a more awareness of the fact that it's prevalent. It's prevalent within our community, and it touches upon every strata of society. From people that are captains of industry are not exempt from committing acts of domestic violence, or, politicians, or, men are capable of it no matter what status they are. And it's just rampant. And I think jurors and the community generally is just much more aware of it. And through things such as, your reportage of what goes on in the courts.
Yeah, and as you say, they're always hard cases to cover because, like any sort of major crime or incident, you always feel like a little bit of a voyeur into the worst, parts of people's lives, and there are very, particularly in DV cases, very intimate details about what was said, what was done, what led up to it. The he said, she said allegations. There's often children involved. They can be extremely challenging to even witness, let alone I'm sure. And report on. But I'm sure then defend and or prosecute, because that's just the life of a lawyer, I suppose. You get attached to one side or the other, not attached in a professional sense. I mean, not in a personal sense, but then you become, I suppose, particularly in very personal ones, you become part of the conflict yourself, even though you're trying to help a court and not necessarily help one side or the other.
Yeah, well, yeah, yes and no. I mean, I think we have to remain, independent of the whole thing, because we shouldn't be personally involved in it. Particularly if you're prosecuting, you should be disinterested. And I don't say that in a disparaging way, but you should be disinterested in the outcome. It should be just about ensuring that the process is correct and letting the decision makers decide, letting the jury decide. And you're not, for example, the lawyer for the complainant. They're not your client. It's very, very important to remain. It's not so much remaining aloof, but it's just remaining professionally. The word I'd use is disinterested in the sense that you just do the right thing. Make sure that you run a fair trial, fair for all concerned, fair for the victim and her family, as well as fair for the accused man.
How do you think the courts and the justice system could make the process easier in these type of cases, Bernard, or is that an impossible dream?
No, I think it's easier than it was when I started out, simply because I think that the judiciary is better trained than it once was. I mean, I'm sure that they're getting ongoing training in matters involving family and domestic violence. As I say, the techniques used by lawyers are improving, because it's pointless to be that guy that used to, practice back in the 1970s or the 60s or whatever, where any victim was fair game. So I think it is improving. The victim support office offers support to witnesses and complainants. I think, as a general proposition, everything is improving, but as with everything in the law, it does take time. Change it's
glacial at times, but
it can. Yeah, it's more evolution than revolution, if you know what I mean. Yeah.
Well, Bernard, thanks so much for giving us some light and shade into a picture that is sometimes seems just to be black and white lines in these cases. So, thanks very much for being the premier guest on Caught in the Act. Really appreciate it.
Thanks so much, Tim, for asking me, and I hope it's been of some benefit to everyone. Thank you.
And of course, if you or someone you know is affected by domestic violence, then confidential information, counselling and support services are available via 1-800-RESPECT, which is available free 24 hours a day, 7 days a week, to support anyone impacted by domestic, family or sexual violence. That's 1-800-RESPECT, 1-800-737-732. So, thank you for joining us for the first episode of Caught in the Act. You can, of course, find us at thewest.com.au or wherever you get your podcasts. And if you have any questions for us, you can email them in to caughtintheact@wanews.com.au. And, of course, if you want to know what's happening in court, don't get caught short. See you next time.